This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are talking with Frank Buckley about his new book, The Republic of Virtue, How We Tried to Ban Corruption, Failed, and What We Can Do About It. Frank Buckley is a foundation professor at George Mason University's Scalia School of Law. He's the author of a number of books, two of his most recent, in which we featured here at Law and Liberty, The Way Back, Restoring the Promise of America, which came out last year, and a couple of years ago, The Once and Future King. In addition, Frank Buckley is a frequent media spokesman or guest and interviewer, so we're glad to have you on the program, Frank. Thank you so much for being here.
Well, I'm delighted to be with you. Thank you.
All right. So the Republic of Virtue, How We Tried to Ban Corruption, Failed, and What We Can Do About It. You open the book with America's Machiavellian moment, which is the election of 2016. You have a weekly column in the New York Post where you talk a lot about what the Trump presidency is doing. You offer at times praise, at times criticisms. Your thoughts after year one of Donald Trump, is it what you thought or what do you think at this point?
Well, it's not the case that I want to apologize or defend every one of the extraordinarily impolite and crude things that Trump has said from time to time. More importantly, however, there is an intellectual core to the movement that elected Trump, to the policies that elected Trump, maybe not a movement. And those are worth talking about and worth discussing.
Yeah, so it seems to me from as I've looked at this president in the first year, most of his successes, I think, have been, conventional, conservative, movement type things that he's done well. Tax cuts. He's actually done something and has a plan, at least those he's put in place over these different departments for dealing with the administrative state. We've seen promising moves in curtailing a lot of the excesses of the administrative state. In addition, it seems, there's this idea of bringing in excessive regulations as well that have been issued by President Obama. And so, a lot of things that conservatives always talk about doing, but he seems to be doing them, but we haven't really seen to my mind, the sort of more populist, conservative things that a lot of people thought he might do, such as free trade or immigration. And I'm not sure, as we were talking this morning on the 12th of January, where exactly the immigration deal is going to come down on, but it seems that part hasn't really happened.
Yeah, well, you mentioned a lot of things, and it would take me the next 50 minutes to respond to all of them, but let me take them part by part. You're quite right that in some respects what we've seen is perhaps more conservatism than Trumpism. I take that as a criticism, of course. I don't regard the traditional conservative defense of certain parts of a tax code as in any respect desirable. I'm thinking, for example, of the wretched carry interest provisions of the code. Trump wanted that out. He campaigned against it. This is an entirely unjustifiable way of putting money into the hands of hedge fund managers. Trump wanted it out, but he got rolled by K Street and by Congress. In that respect, conservatism won, sadly, and Trumpism lost, unfortunately. In other respects, I think what we've seen mostly is the kind of confidence that comes from the idea that the person in the White House is not somebody who really wants to beat up on Americans or American business. And as you've mentioned, administrative law, I think the point is that business is responding to the idea that we're not going to be hit with a ton of new regulations. But of course, the deep state and the administrative state remain. I mean, it's very, very difficult to get rid of that unless there's major surgery. And Trump said he thought we could get rid of about 70% of our regulations. I agree with him, but it won't happen unless you have something very, very, very radical. For example, a regulatory reform commission that, like Tribonium in the time of Justinian, just goes out and rewrites everything. That's simply not going to happen with appointing various people to run, for example, OIRA. That slows new bad things happening, but doesn't remove old bad things.
Yeah, no. As I've watched and observed, and Christopher Demuth had a nice op-ed in the Wall Street Journal a few weeks ago, sort of detailing some plans for more long-lasting reform efforts with regard to the administrative state that are being thought about. One would be regulatory budgeting, but I suppose that's all about willpower, staying power, and sort of having the creativity and fortitude to do it.
Yeah, and you also have similar initiatives based on a litigation strategy associated with people like Philip Hamburger.
Yeah, that's right.
And as I say, I just you see, I don't think that sort of thing is going to help very much. Why? Because the cruel logic of the administrative state is that it requires regulators to regulate things. That is, they can't be done by Congress, and they can't be done by the courts. So a litigation strategy to take on the administrative state will in the end fail. And similarly, kicking it back to Congress, where, with a bunch of 27-year-olds sitting around trying to figure out what the heck some regulation is all about, I mean, that wouldn't work either. I think what would likely happen, in other words, would be what has happened in the past, basically Congress just saying uncle and giving in to the regulators, to the administrative state. So you need something vastly more revolutionary, as, for example, the suggestion I made of a reform commission that just goes in and rips it all up.
No, that would be interesting to see happen. Thinking about the book,
yeah, Napoleon did it as well, of course. Napoleon replaced all the law of civil delict, the law of torts, with 2 articles of the Civil Code.
that would require, yeah. So that would power in the executive. That would require tremendous power to make this possible.
Well, what it would require would be basically a completely different kind of Congress. It really would require eliminating the filibuster.
Yeah. Well,
there's no reason for that.
Yeah. Well, so thinking about the book, The Republic of Virtue, first section of the book on corruption, the United States of corruption. Maybe detail for us your case for how corrupt America has become.
Well, we're fairly mediocre on cross-country ratings of public integrity of corruption. And by the way, when we speak of corruption, we're talking about public corruption. That is, we're talking about self-interested political leaders, benefiting themselves at the expense of the country as a whole. The very opposite of the kind of disinterested leaders that the founders of America hoped we would have. You mentioned the idea of a Machiavellian moment before, that's a phrase of J.G.A. Pocock, the historian, who said that the founders were animated by a desire for Republican virtue. That is, again, the set of disinterested leaders who would prefer the public interest to themselves. And I think we saw something very much like that in 2016, given the fact that the Democratic candidate was going to be Hillary Clinton, the very personification of corruption. I mean, we're told, by the way, that right now she aspires to be a Methodist minister. And one remembers what Baudelaire said, that he would be surprised how such a person might be permitted to enter into a church. What conversation, after all, could she have with God?
Thinking about the public corruption, I mean, it's interesting your analysis. It doesn't seem necessarily to build upon what a lot of people in the American right would talk about, which would be sort of progressive deform in the early 20th century, moving up through the New Deal. You sort of emphasize or go and place blame, beginning with Andrew Jackson, as sort of the upending of the founders' Republican virtue, and then you sort of build from there on the sort of enlarging power, both of the executive, but also sort of the virtues or vices of democracy infecting America.
Well, I spent a lot of time in the book talking about the framers of the Constitution, and the point I make is that one understands nothing about the Constitution unless one understands it was meant as an anti-corruption covenant. That was the argument that won the day, and but for that argument, we would not have had a single country. We might have split apart. Parts of America might have returned to the British Empire. I mean, there were British spies waiting around to pick up the pieces. So when everyone was divided, it was the argument about corruption that won the day, and that is why the leading figure of the convention was Gouverneur Morris.
Yeah.
Who figured it out more quickly than anyone else, that this is the way to make it all work. These were the arguments that would persuade people to come to the table. And then when you look at the Constitution itself, here, there, and elsewhere, all over, are these provisions which are designed with the idea of preventing corruption from rearing its ugly head.
Yeah, talk about Gouverneur Morris some. You spend a lot of time in the book describing his role at the convention and sort of the way he brings things together on this subject of defanging public corruption with the new Constitution.
Well, he was the man of the convention. I mean, people describe the convention, the Constitution, as a Madisonian Constitution, which is the equivalent of posting "don't know much about history" on your forehead, because the Madisonian Constitution is one in which you would have had an elected House, but the House appointing the Senate, and both together appointing the President, and with a national veto over state legislation. And you have all of that, of course. You have that in Canada, so therefore the truly Madisonian Constitution is Canada, the British North America Act, right? And what happened in the case of Madison in Philadelphia in 1787 is he didn't get what he wanted. And, he was one of these fellows who thought he was one of the smartest people in the room, and who many of them did, and who was singularly inflexible with respect to his pet ideas. And after, on July 16 of the convention in 1787, after July 16, after the Connecticut Compromise, Madison's plan for the Constitution completely fell apart, because what he wanted was the kind of filtration I just described, where cream rises to the top and we get a president appointed by the Congress. But after the Connecticut Compromise, the Senate would be appointed by, members of the Senate would be appointed by state legislatures. And so the states whom he feared would be at the very heart of the national government. It took Gouverneur Morris to figure it all out. On the morning of July 17, Madison, I think, wanted to lead a walkout. Madison would have wanted to destroy the country on the morning of July 17. And within a couple of hours, Gouverneur Morris turned it entirely around, because what Morris realized was, well, crucially, what we want is a strong national government, and an elected president will get us that, as it has. So for Morris, nationalism trumped filtration. That was July 17. He didn't persuade Madison that day. But Madison came aboard 2 days later and started to talk about Montesquieu and the separation of powers. And in the end, it was Morris's vision that won the day, and that's why July 17, 1787 is the most important date in American history. And that is also how we got our strong presidents, notably Obama, who could, wave their pen and make laws for us.
We think about the presidency, though. I mean, this is the powers of the president as discussed or thought of by this group of framers. There is clearly this idea of the president not being able. It seems to me their model is the fear of the British monarch, and you talk about that some in your book. Certain provisions in Article 3 to limit presidential power. You also talk with Gouverneur Morris is this idea of a national election, but electoral colleges that would be controlled by state legislatures. And so it seems to me, there's this sort of this unwinding process that happens where these sorts of commitments or things that they think are doing are going to be undone.
Well, nobody quite knew how it would all turn out in the end. In the end, they compromised, but over very different sorts of things. For example, those people who were nationalists, like Gouverneur Morris, thought you'd have perhaps more virtue because corruption was to be found amongst the state governments. But the states' rights people, like Roger Sherman, thought just the opposite, that the states were closer to the people and therefore would be more willing to defend the people. And so they compromised over all of that, but did they all have a single vision of how it would turn out? And the answer is, of course, no.
Yeah, yeah, but I guess it seems to me to say, I mean, that's to attribute or to go from, say, the executive of the Constitutional Convention to Obama leaves out a lot, don't you think?
Say that again?
To move from, say, from the way we do presidential power now from what Gouverneur Morris was articulating, or
Oh,
I mean, that seems to, if I understood what you were saying correctly, maybe I didn't. It seems to omit a lot of history and
you're asking me, did the nationalists understand
yes,
that with the method of choosing the president that they supported, did they understand that that would give us the strong presidency of
that's
today?
right, that's right. Yeah.
Not so strong as it has turned out to be, but yet they thought this would be a way of strengthening the national government. And to that extent, they liked a system which was not a system of popular election, but a muted system, which in the fullness of time gave us a popularly elected president. They didn't understand that the president would be so powerful, I think, for a couple of reasons. And the principal reason is the size of government. I mean, Washington, the national government was so much smaller then, they could not have anticipated the huge expansion of the federal government that one sees today. And while they thought that, you know, the locus of power within Washington would shift towards the presidency, they didn't think the focus of power throughout the entire country would shift to the national government.
Yeah, no, and there's also this idea. I mean, we see it articulated in the Federalist Papers of the president as exercising sort of or being an auxiliary precaution and having a role of, maybe checking legislation or runaway legislation. That seems, in my mind, to be completely undone today. With the president is just as much involved in producing or getting legislation produced as he is in trying to be some sort of, wise figurehead stopping legislation.
Yeah, whether Madison and Hamilton believed what they wrote in the Federalist Papers is very much a nice question. Of course, they were the great losers in Philadelphia. They were the people who most disliked what we ended up with in our Constitution. But then they set out to write what securities lawyers call a selling document, basically an advertisement for the Constitution in the Federalist Papers, which were read in New York State and not much elsewhere.
Yes.
Somehow the idea that we should turn to them for an explication of the Constitution is a little risible.
So thinking about virtue here, the discussion of virtue, what are the virtues that the framers thought were needed to maintain a republic? And you give sort of a standard account of the extensive republic that Madison articulated as being what the Constitution would provide for in terms of checking corruption, but virtue itself, are they thick enough on that in terms of connecting that with being a republic?
They never talked about virtue per se in their deliberations. What they talked about was the opposite of it, which is corruption. They never thought they had to define much corruption either, except they had some of them, the nationalists, had a very clear sense that nationalism meant a commitment to the whole country as opposed to the particular parts. And of course, recall that in the Articles period, much of the problem came from barriers to interstate trade. And that's the sort of thing they wanted to get rid of. Trump is accused of being a nationalist, as he is, in fact. But the idea that there was something wrong about nationalism would have been very puzzling to George Washington, who was a great nationalist. And, of course, very, very puzzling to Abraham Lincoln.
Yeah, well, thinking about, so how did they define, and maybe that can help us understand more of what you're arguing, corruption for them would be the public use of office for private gain?
Yeah, corruption would be a number of things. It would also be bargaining over offices, or log rolling, as we would call it today, and I think there are very few people who would describe that as corruption today. I mean, consider, for example, the almost obscene log rolling that took place when we got Obamacare. Remember the Cornhusker kickback and Louisiana Purchase, and And those were distasteful, but they didn't directly benefit the people who were behind them. They were done for the benefit of the state. More troubling still is something I talk about in the book, which is campaign finance problems. What happens when there's a payoff directly into the pockets of a candidate, or if not directly into his pockets, then to his campaign finance committee? Okay, so there's more of a direct quid pro quo in those cases, obviously, than a log rolling that's not meant to benefit you personally.
Yep. So you think about, just in terms of this overall case for corruption, what undoes it? We get the nationalist constitution, we get the broad election of congressional representatives, we get senators coming from state legislatures. Obviously, that's been overturned. But to your mind, what are the things that reduce the anti-corruption covenant to the United States of corruption, as you term it?
Well, I guess the presidential form of government could not be counted a plus. I'm thinking again of Obama, and God knows what we would have seen had Hillary been elected. The IRS scandal, many people would think is a prime example of government misbehavior. And when news of it first emerged, all the newspapers, the New York Times, et cetera, thought this was absolutely terrible. And then the administration just sat on the news for a long time, and a couple of years later, the New York Times walked back its criticism of it, and Obama said there's not a smidgen of evidence of misbehavior here. So the control that the executive branch has over the flow of information means that it can cover up corruption more easily than would happen in a parliamentary system, where, after all, question period is really the opposition's playground, and if it wants, it can just hold the government's feet to the fire as long as it wants, and governments have fallen over that sort of thing. And you compare that to the congressional committees investigating the IRS, and it's our system is rather pitiful when it comes to constraining corruption in that sense.
Yeah, thinking about John Koskinen, who was the head of the IRS, appointed head during the investigation. He was openly lying to Congress and daring them to do anything about it, and they did nothing.
Yeah. So Congress is without power, effectively, to constrain bad behavior in that sense. It has a police power, which it's not going to exercise. It'll turn things over to the Justice Department, and we know what that meant in the time of Obama, or in presidents generally, in most cases.
So your thoughts, though, thinking about this one, we had just talked about one particular battle between Congress and the executive. And I'm thinking also about the virtues of a republic. Why has Congress become so complacent or compliant or subservient in defending its own
interests? Well, there's a lot of irresponsibility built into the American system. There's a lot of finger pointing. This is something Woodrow Wilson pointed out. The point is, by contrast, in a parliamentary government, when there's something bad that happens, we know who's responsible: the government. When something bad happens in this country, when there's a dispute, you get a lot of fingerprint pointing, and it's hard to say who exactly was at fault in those cases. So, with respect to raising the debt limit in 2011, everybody said, Obama said, it's Congress that's at fault, and Congress said, no, it's Obama. He won't talk to us. So
is that the system? Is that the system though, or is that just sort of this hyper-partisanship, and sort of which would be? I guess that's a part of the problem, that hyper-partisanship has sort of outdone this idea of separation of powers, and that members of institutions would see to it that their own interest is in securing the institution's power, that this has somehow been outweighed by partisanship.
That again is in part a function of the American system of government. What you have here are local bases of power that don't respond to a national party. In a parliamentary system, it's basically, two parties aiming for the center in both cases, and constraining what the members can say and firing them if you don't like them. Well, you can't do that when you have an American presidential system of government. Why? Because you don't really have a national Republican Party. You have a presidential party, and you have You have a bunch of congressional parties. You have the party of the Freedom Caucus, and you have the party of whatever was in the head of John McCain this morning, but it's not a national party.
Yeah, but it seems to me there's something more at work. I mean, there are clearly tools in the Constitution given to Congress to, blow up the Capitol if it wanted to, and it doesn't use them. It doesn't see fit to use them, or have the courage, or the energy, or the desire, or the, all of these tools within Article 1 that they could use to defend their interest, and they lie dormant. One of which, thinking about impeachment, you spend some time in the book talking about that, and yet that is kind of a dead letter. In many respects, it doesn't seem to be things that we want to employ on a regular basis to fight corruption.
It was meant to be something that would police corruption more. The crucial change came at the end, and nobody noticed it. You require 2/3 of a Senate to remove, not 1/2, as everyone thought would be the case. I don't know. There's something rather special about Americans in all of this. I think that Americans are people of loud ebullience, but also of quiet nobility. That is, they're also cynics in a way, but they're cynics who, like Humphrey Bogart, are privately virtuous in the sense that, well, they look around at the world and they see it's quite fallen, yet they themselves could not live with themselves were they to think of themselves as corrupt in some way. Humphrey Bogart in Casablanca is, I think, a rather good model. So that's why corruption has been something that has bothered us. And that has given us a lot of, I think, false starts. For example, our election laws. I spent some time talking about that in the book. I think that in general, we'd be probably better off if we simply got rid of virtually all of the election laws we have, or the campaign finance laws we have, all those things which constrain spending on elections, and which have the curious feature of a net that lets the big fish sail through, but stomps on the small fish.
Yeah, no, and I think this is, and you make this point briefly in discussing the election laws, that the disclosures and accountability that you are held to in forming, say, a political campaign limits you greatly, or discourages many people from actually getting involved in various ways in politics, and then we turn around and are surprised that a lot of people don't get involved. But the government is actively discouraging you, given what you are required to do and the types of penalties you could face if you don't disclose your political involvement accurately.
Yeah, I was involved in forming a group called Scholars and Writers for America, a pro-Trump group of intellectuals, which is something I did for the sheer perversity of the thing as much as anything. And I guess at one point I realized, wait a minute, there's a $1,000 limit with respect to expenditures, and that means that we really can't do anything about this unless I go through these really incredibly convoluted procedures for forming a political committee. I mean, it's just like 140-odd page booklet about what to do, and it just wasn't going to be possible. So in the guise of trying to promote purity, what we've done is we've made our elections less competitive, and in the process, I think also made them less virtuous, more corrupt.
Yeah, it was interesting. You quoted Brad Smith in that section of the book, and I remember hearing him lecture one time, and in the middle of the lecture, he read a letter from a former Army lieutenant who had campaigned for Congress and had lost, and had been under, I think, no, I don't know if investigation, but the Federal Elections Commission had come back to him time and time again for various disclosures, and he wrote a letter describing what had happened to him, and that it was, his opinion that people like him were not supposed to get involved, that they were actively discouraged.
Right, exactly.
That's always stayed with me. Yeah.
Yeah, politics is far too important to be left to ordinary American citizens, which is why we need campaign laws so extensive and so mind-numbingly detailed that it really requires a lawyer to be at your side to navigate through them. And that's the poor innocent schmuck gets nailed, and the big guy gets through. I mean, at this point, what with super PACs and what with the expansion of campaign limits, there's really no limit to what a smart guy can do with a lawyer in terms of supporting a candidate. You can contribute up to about $350,000 a year to a presidential campaign if you do it wisely and comply with all the rules. but Dinesh D'Souza got nailed for spending $20,000 on a candidate. So
Yeah.
the fool didn't have a lawyer beside him.
Yeah,
But is politics something that's going to require a lawyer beside you?
so you advocate reforms. Are all donations to a actual campaign would be anonymous?
This is called dark money by people on the left, right? And when people on the left write about corruption, and this is mostly a theme for those guys, when they write about it, what they're talking about is a scandal of Republican money.
Yeah.
They're horribly partisan, right? The only enemies in town are the Koch brothers and the like.
And then,
the Koch brothers are simply ideological, right? And they're a bunch of most of the big time donors are very ideological. That's fine, but
and then of course
I don't see anything.
Yeah, go
I
ahead.
don't see anything particularly wrong with that. If you had anonymous donations, that would remove the taint of pay for play. In other words, if a candidate received money and didn't know where the money was coming from, the candidate would not be able to confer a favor upon that donor, which is to say you'd not have pay for play. And some people will say, yeah, but you can't really
regulate
prevent the big donor, nudge, nudge, wink, wink, from communicating a message. And my answer is, well, okay, in that case, it'd be no worse than the way we are now. But importantly, it would help protect the small guy who wants to make a donation and not have his name out. So that would protect the Brendan Eishes who contributed a couple $100 to an initiative with respect to California initiative with respect to same-sex marriage. And here in my area, I'm in Alexandria, looking across the river at the district. There's a website out here called, I forgot, I won't even give the name, but it lists every single person who donated to the Trump campaign in 2016. And, it's very clever. At the top, it says, these are your neighbors, and below it says, fascism has its consequences. It gives the name of the donor, it gives the address of a donor, it gives the name of the donor's wife, and it'll tell you things like, here's where this donor goes jogging.
Wow.
I bet our guys could jog faster than she could, huh?
Yeah.
And of course, they covered up by saying, of course, we're not recommending violence. Yeah, right. Well, but that, this is what's happening. There are internet mobs out there, and campaign finance laws, particularly disclosure requirements, simply make it difficult to contribute to conservative candidates. We know that the mobs are on the left.
Yeah.
There aren't mobs on the right, and so the danger comes from the left as against particularly Trump supporters. And and of course, as far as the media goes in the United States, this would not be a problem.
Well, and then of course, harkening back to the IRS scandal, the whole point was to identify. That was part of what was going on. We had one case where the IRS actually not publicly, but released donors to an outside group for the purpose of punishing. So and I take your point there. You also talk about limiting or preventing registered lobbyists from bundling money or giving money to candidates.
That's the one thing
I like that idea, but I thought that probably isn't going to pass, or if it does, it would have a million loopholes.
Well, the point is, let's take the focus away from the Dinesh D'Souzas of the world and let's focus on K Street.
Yeah.
And there are a couple of things we can do. There was a big scandal about 10 years back involving Jack Abramoff, who was taking people to play golf in Scotland, spending a lot of money on them. And that gave us a law passed about 10 years back called H-Laga, which banned direct contributions to a candidate, direct presence, junkets to a candidate. But lobbyists can still contribute to congressional campaigns. They can still organize receptions, meet and greets. They can do voter research for a candidate. They can be extremely important in helping a candidate get elected. Now, the other thing they do is they provide information to a candidate. And, these candidates, they arrive in Washington as newly elected congressmen, and they know beans. And it is very important that they be permitted to get information about what's happening from lobbyists, right? Exercising their First Amendment rights to to inform government as to its misdeeds. So we don't want to stop that. But in addition, we don't think they should be permitted to make campaign contributions. So there are some precedents for that. I think that would probably pass constitutional muster.
Yeah.
And I would, in addition, have no problem with erecting a barrier between congressmen taking jobs on K Street after they leave office. And right now, about half the congressmen who leave office thereafter take a job on K Street as a lobbyist. And when they do that, they increase their salary by 3, 4, 5, tenfold maybe. So they're going to cash in with the result that one congressman said that Congress has become the farm team for K Street. Now, here's the problem. The problem is, if you think you're going to work for this lobbying firm and somebody from the firm calls you up and asks for something and you're the congressman, you'll be tempted to say yes or no, sir, 3 bags full, because this is your future employer.
Yeah.
So, that's got a scandal, written right into it. This is a sort of thing, by the way, which puts trial lawyers into jail, where they do the same thing to judges, offering them a position in their firm after they leave office. That's how Dickie Scruggs in Mississippi was put in jail.
Yeah, no, you talk about that. That's an interesting part of the book in terms of reforming diversity jurisdiction in the United States as a way of eliminating toward hell. Yeah. I was curious.
We didn't talk about federalism, and when some people say, I don't know if we're all that corrupt, we're Americans, we're not that corrupt. My answer is, there's this place called Illinois. You ever hear of it? Or Louisiana. So there are varying degrees of public-spirited leaders in different states, and if you're in a corrupt state, you're going to pay for it, right? Very corrupt states are Alabama and Mississippi, and these are not exactly prosperous states. So there will be a gravitational pull in terms of location decisions towards more reputable states, from Louisiana to Texas, for example.
Yeah.
Now, when federalism declines and all the power is centered in Washington, the ability to escape corruption becomes that much harder. You can escape Louisiana corruption, but you can't escape national corruption very easily. So that's one problem with the decline of federalism. But in one respect, as you note, I suggested I'd like to see more powers given to the federal government, and that has to do with the practice in some states, again, places like Mississippi in particular, that have the habit of sticking it to out-of-state people. And I drew a parallel between what happened in the 1960s to outside agitators, people from the North who came down to protest civil rights laws in Mississippi, and what happened with respect to the trial lawyers of the 1990s and thereafter, the people who got jury awards for enormous amounts of money against out-of-state firms. And what was common to both of them was an inside cabal of locals who had all the levers of local power and who didn't make a practice of talking to outsiders and who stuck it to outsiders. And the interesting thing is, it's the same people. Yeah. Right? It's the same people. It's the guys who were part of that horrible racist mafia in the 1960s simply transmogrified into trial lawyers. Right? And what's interesting is, the trial lawyers, the Dickie Scruggs, became national heroes for the left in the 1990s, up to the point where Dickie was put into jail for bribing a judge.
Yeah, no, we really forgetting he's Trent Lott's brother-in-law, which is also interesting. So you talk there about eliminating complete diversity in the sense of, which allows Dickie Scruggs trial lawyers to file a case in Mississippi against the out-of-state defendant as long as they sue one in-state defendant.
Yeah, apart from de minimis small dollars cases, whenever you're sued in state court, whenever an out-of-state firm or person is sued in a state court, you should have the right to turn it over to federal courts. And we made some move in that direction in legislation about a dozen years back. It's not perfect. It could be made a lot better. And then what I suggested was simply one way of doing that. Just give, you're out of state. You know,
Yeah.
there's a Homer bias, a bias towards favoring your own state that argues for kicking it into federal courts. And that, of course, was exactly what happened in the 1960s. I mean, after the murders of the civil rights workers in Philadelphia, Mississippi in 1964, the feds got involved. Robert Kennedy and John Doerr sent their people down there to investigate what was happening. The state, I guess the state attorney general asked for the witness list from the feds, and the feds refused to give it because they knew that the local state court was so corrupt that you couldn't possibly, imagine a fair trial if they had anything to do with it, right? That's what we thought about the state courts of Mississippi in 1964, and we still have that problem.
Yeah, it's interesting here too. As I was reading this part of your book, I thought of your colleague Michael Grava and his analysis of the famous Erie Railroad decision, in his book The Upside Down Constitution, where he argues that Erie Railroad, in sort of eliminating the possibility of a federal common law, which applied and regulated in various ways and facilitated national commerce, and so corporations knew or had a good sense of how they were going to be held liable or judged throughout the country, that the Erie decision had this effect of raising the power of state courts, particularly with regard, and I wondered how that fit with your analysis of the trial lawyers. It seemed...
Bad idea. What Grieva suggested, though he didn't know it, is the Canadian solution, which is a federal common law.
Yeah, you said that, and I thought, we kind of had that, and then Erie Railroad,
And and what we have is actually superior to that. We have the possibility of local state common laws, and that can produce a race to the top in the provision of private laws, just as it does in corporate law. And that's superior to the Canadian solution. And all we need to do, however, to cure the problem we have is bring in the feds when there's a problem of bias. And the problem of bias, that is to say corruption, arises when you have a plaintiff in one state and a defendant in another state.
Yeah.
That's all we need.
So thinking your last chapter in the book, The Heavenly City of the Enlightened Reformer, talk about that.
Well, the title of my book, The Republic of Virtue, was meant to be ironic, although I didn't underline that. And what I had in mind was that when you begin with the idea that we are perfectible, when you begin with the idea that it is necessary only to do that which the people want, and it's easy to know what that is, you can end up too easily with a Robespierre. I mean, Robespierre was a perfect example of a fellow who wanted the Republic of Virtue. You contrast his view about humanity with that of the framers and their notion of a very fallen humanity. And if you're a conservative, you've got to appreciate the wisdom of the framers in that respect. They were, with all their contempt of democracy, they nevertheless had a very clear idea about how a pure republic of virtue wasn't going to be possible. And that the best we could do would be to arrive at a structure of government which is best, which hopefully would go some way towards producing a public-minded set of leaders. And we didn't quite get there, right? Mm-hmm. But that was the goal.
So your thinking there is these reforms will require certain people with a sort of Republican virtue to make them happen.
No, I don't think that. We're a mixed lot, but it's not the case that we can assume that voters will always prefer the most noble characters amongst us. And we began by talking about Donald Trump, and nobody would suggest he is the noblest American of them all. So, but one's more interested in not so much individuals, but a structure of government which produces good government. That's where the framers were coming from. They had Washington before them on the dais. They knew that Washington was a personification of Republican virtue. They didn't expect that they'd see too many Washingtons in the future.
Yeah, no, I think that's right. Frank Buckley, thank you so much for discussing your latest book, The Republic of Virtue. We appreciate your time.
Oh, Richard, thanks so much. Great talking to you.
This is your host, Richard Grinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.